Dr. Townend had preferred that the chair not push everybody else out for his presentation. So I'm going to do mine just in a summary form. So I'm looking at social media speech. And the idea comes from this idea of a conversation in writing. So there's this now well-known case coming from Canada, where I'm from, in case you're blaming me for what happened in the US. And this gentleman posted, he and his twin brother posted something on one of those websites like Rate My Professor, and it was quite nasty about this one individual, so it went to court. And this was his testimony about what he saw social networking be. And I particularly like the last quotation. I think it's kind of cute. Coming from an employment law background, I know that's not the case. So, but this idea of social media being a conversation permeates a lot of the lay understanding. Whereas in law, the way we look at it is influenced by defamation. We look at it as libel and slander. And social media is basically a transcript of your conversation with someone. So what is happening, you see this a lot in employment, people saying, I didn't know I could be fired for something I put on my Facebook page. And the utter surprise at this happening. And so this is a really, I think, important distinction that's coming out between the lay and legal understandings. So there's this disconnect. Now we can get into different things, and some of the some of the previous presenters have talked about privacy, and there's an overlap with defamation and privacy that is emerging. Mr. Justice Eadie has mentioned it in 3 years ago, I think it was. He started mentioning this. And also there's this idea of intrusion that Mr. Justice Eadie had brought in. Intrusion into something private. And there's a Canadian case called Jones versus Dissecting, which brought into law, arguably, Professor Prosser's article from the 1960s that outlined what is private. And he gave these 4 criteria, and intrusion upon seclusion was one. Jones is a case where facts, because I'm not involved, are actually quite funny. But this lady was dating the ex-husband of Jones. And she worked at a bank where Jones did her banking. And she looked up her personal banking 147 times over her period of employment at the bank. So the court said, well, this is intrusion into something quite private. So there's this emerging idea that maybe there is this private space. And I'm suggesting that we get into this through concepts of audience and authorship. And we can look at this, it's not necessarily teased out in defamation, but we'll see it in things like defamation of someone who's a professional. The well-known case, Drummond-Jackson. If you say your dentist has shaky hands, that would be defamatory because it strikes at his ability. Thornton and Telegraph Media. Sometimes you write for certain audiences. And I think there are overlaps here with how we converse on social media. So if social media is going to be looked at in a legal sense, taking from the defamation aspect, maybe we can also draw from the law to say maybe there are protections in certain circumstances. This is a closed group discussion that I'm having. My 4 friends and I are having this discussion, and we may say things that are outside of the bounds, not necessarily for other people, but this is for us. And the argument, I think, would be, well, this is part of the self-development that is often put in with free speech. I want to talk about Singh for a minute as well, British Chiropractic Association versus Singh. I've always found this case very interesting because if you remember, for those of you in the area, if you remember when it came out, this was sort of this leading up, if we now look back to the Defamation Act 2013. So this common law change that we were seeing. And in Singh, a very robust panel of the Court of Appeal said, no, Mr. Singh should not be sued for defamation by the British Chiropractic Association. And I tap into this as an authorship and source idea because Mr. Singh was a well-respected journalist in science, a well-respected commentator. I believe he had advanced degrees in science from well-known universities. And there's this idea sometimes that on social media, if we look at the Twitter aspect, some Twitter accounts are taken more seriously than others, although news from the US today may disprove that point. So then we have the history of breach of confidence, and Professor Phillipson, now a little while ago in the MLR, had talked about this before a lot of the developments had come about. So I don't want to repeat what he had said, but we have the cases here. And then we have this point of distinction coming about in 1990 with the Attorney General and Lord Gough. And then Lord Hoffman talking about, well, no, that's not quite actually the way it is. And so then we start to see this separation, or what may be a separation, because I think it's not quite clear. Hopefully, it will become a bit more clear with the decision coming from the Supreme Court, but who knows. But the idea is we have breach of confidence as an equitable remedy, but we also have misuse of private information. And there are these two ideas running concurrently that is a bit hard to follow. I think the very simple point for us for social media comes from McKennett and Ash. McKennett, a well-known musician, shares her life experiences with Miss Ash. In a private setting, they become very good friends, and she just says, this is what I've done. And Ash writes it all down and tries to publish this as a book. Well, the court was very clear, this is a breach. This is taking something you received, taking information you received in a private setting and trying to impart it. So I'm just summarizing the points, and PJS was already alluded to earlier, but will be discussed a bit later. I think it can fit into the discussion as well. So what I'm saying here is I'm happy to talk afterwards because I don't want to keep people from lunch. But if you have questions, I'm happy to take them. But I didn't want to take, and Dr. Townend didn't want me to take time from the other panelists and to give them some more time to present and take questions.